Yes, the sources describe a number of filings supporting Lively's MTD that seem pretty standard for this kind of thing. They come from groups you might expect to see weighing in on a case involving survivor speech rights.
How many are we talking about?
The sources mention a coalition of 19 advocacy groups and individuals filing briefs in support. That number alone tells you something that a lot of different players see this case as important beyond just the two main parties.
And any specific groups named?
Yeah, the sources highlight organizations like Child USA and Sanctuaries for Families. These are groups focused on, child protection, supporting families dealing with abuse and trauma.
So their interests make sense.
Right. You can see why they'd be concerned about laws protecting people who speak out about misconduct. Their briefs would likely argue why that protection is crucial and what the negative effects might be if it's weakened.
The sources also mention an individual filer, Elise Dorsey.
They do. And significantly, the sources note she's an attorney and her brief was filed through a law firm, Steptoe.
Why is that detail important?
It just underlines the standard process. Even a legal expert files formally through counsel, making sure everything meets the court's requirements. The sources mention this case is in the Southern District of New York. The SDNY and federal courts like that have very specific, sometimes complex rules for filing anything.
So Dorsey's brief, filed through lawyers, and the briefs from groups like Child USA. These all sound like standard practice. They're supporting Lively's motion, arguing about the importance of the anti-cell APP law.
Exactly. They represent the typical way interested third parties with relevant knowledge try to offer helpful context to the judge. They're playing by the established rules of the legal game.
Okay, so that's one side of the Amicus coin, as presented in the sources. But then there's this other filing, the one described as highly unconventional.
Yeah. This is where the story takes a sharp turn, according to the source material. It talks about another Amicus brief filed, but this one is different. It's described as being from a certain YouTuber, someone who is not an attorney, maybe a former professor, the sources speculate, but definitely not a lawyer.
Not a lawyer.
Okay.
And what about the content of this brief? The descriptions in the sources are pretty wild.
They really are. The commentary is quite critical. The sources say the brief argues something along the lines of men are mistreated in our society, which, immediately frames it as a broad social grievance rather than a specific legal point relevant to the motion.
And it gets worse from there, based on the source description.
Oh, yeah. The sources use phrases like MRA garbage, men's rights activist type stuff, and victim blaming to characterize the argument.
Wow. Victim blaming in a court filing.
That's how it's described in the sources, yes. There's also anticipation mentioned that it would be Red Pill Plus, referencing those online communities with anti-feminist views.
So pulling arguments straight from certain corners of the internet, it sounds like.
That's definitely the picture painted by the sources. They also claim the brief explicitly argues that the Me Too agenda is bad. So it's directly positioning itself against the whole movement, encouraging people to speak out about harassment.
Which is diametrically opposed to the likely stance of the groups filing briefs for Lively.
Completely. And there's another specific claim mentioned about defamation suits.
Yeah, the sources allege this brief makes this sweeping statement like, only innocent men sue for defamation.
Which is presented in the sources as, a central assertion, but one that's just factually and legally questionable, a very broad generalization with no apparent basis in law.
And the sources point out that other briefs, like the one from attorney Elise Dorsey, actually disprove that very claim.
Exactly. The contrast the sources draw is incredibly stark. On one hand, you have briefs presumably citing law and evidence. On the other, you have this brief described as relying on, trust me bro logic. Just assertions with no legal foundation or research cited.
Trust me, bro logic.
Yeah.
That's not usually persuasive in federal court, I'm guessing?
Not typically, no. And it gets even stranger. The sources mention speculation that parts of it might have even been written using AI, like ChatGPT, and that it might have just made up court cases to cite.
Seriously, fabricated legal precedents.
Yeah.
That's bold.
If true, it's beyond bold. It's potentially fraudulent and certainly grounds for the court to completely disregard it, if not take further action. But the core description is a filing heavy on opinion, light on law, maybe even sprinkled with fiction, according to the sources.
So how does something like that even get near a formal court like the SDNY? Don't they have rules?
Oh, absolutely. Extremely strict rules. Filing something electronically isn't like uploading a YouTube video. There are precise formatting requirements, procedures.
What kind of barriers are there?
Well, for starters, the sources mention needing a specific login to use the court's electronic filing system, PACE-ReCF. You can't just email a PDF. And more importantly, for something like an amicus brief to be formally accepted and put on the docket, you typically need a licensed attorney admitted to practice in that court to file it as counsel of record. They're essentially vouching for it.
So the idea that anyone can file is misleading.
Very misleading. Anyone can try, maybe mail something in, but getting it formally accepted and considered by the judge through the proper channels, that's a whole different ballgame, usually requiring legal know-how.
And the sources mentioned some doubt about whether this unconventional brief actually was properly submitted and accepted.
Yeah, there was commentary noted in the sources. The filer apparently claimed it was submitted and would show up on the docket midweek. But people familiar with SDNY procedure pointed out that the docket updates constantly as things are processed. So the delay raised questions in the sources. Was it really submitted correctly? Was it stuck somewhere? Or was the claim of submission maybe premature?
Which leads to the judge. Judge Lyman, the sources mention. Does he have to read this thing, even if it did somehow get filed?
Oh, definitely not. Judges have enormous discretion over what they consider. They can absolutely accept amicus briefs they think are helpful, but they can just as easily reject or simply ignore filings that are irrelevant, don't follow the rules, lack legal merit, or just seem like attempts to grandstand or inject opinion instead of useful analysis.
So a brief asset, described like this one, trust me, bro, logic, maybe AI-generated cases,
No.
probably not getting a warm reception.
Highly unlikely it would be considered helpful or persuasive to the judge. The focus is always on sound legal reasoning and relevant facts presented properly. Anything else is just noise.
Given all that, what's the perceived impact of this filing, according to the sources? Did it help Baldoni's case?
The overwhelming view presented in the source material is no, quite the opposite. It's seen as potentially backfiring badly on Baldoni, described as a terrible look for him.
Why so terrible? Just because the arguments are described as weak or offensive?
Partly that, yes. The sources suggest that being associated with arguments characterized as MRA garbage, victim blaming, and anti-Me Too could really damage his public image, especially with people who might have been on the fence. It aligns him, even indirectly, with some pretty controversial viewpoints.
And there's an irony mentioned too, right?
Right.
Relating back to the anti-SLAP law.
A huge irony, yeah. The sources point this out very clearly. Baldoni is suing for defamation because Lively spoke publicly about alleged misconduct. Lively is using the anti-SLAP law, arguing his suit is exactly the kind of retaliatory action meant to silence speakers that the law aims to prevent.
Okay.
Then, this amicus brief comes along, supposedly supporting Baldoni, but it's described in the sources as being full of baseless claims, opinion, maybe even fake citations, essentially, using legally unsound methods to attack Lively and the Me Too movement.
So the brief itself kind of embodies the thing the anti-SLAP law is trying to stop, using baseless or improper tactics to shut someone down.
That's precisely the irony highlighted in the sources. It inadvertently seems to reinforce the argument that Baldoni's side might be engaging in the very kind of behavior, using questionable claims to try and bury someone that the anti-SLAPP law is designed to curb. It's not a good look strategically.
What do the sources think the judge will actually do with it?
The main speculation is that Judge Lehman will simply ignore it, just treat it as irrelevant noise that doesn't contribute to the legal analysis he needs to perform.
And there was that interesting side note in the sources that being ignored might be worse for the filer than being rejected.
Yeah, that observation suggests maybe the filer's goal wasn't purely about influencing the judge, but perhaps also about gaining attention or making a statement publicly. Being completely ignored by the court would kind of defeat that purpose.
The language used in the sources to describe this whole episode is pretty striking. Social media clown show. Fatal cringe.
Those phrases really capture the perception, as reported in the sources, that this was an attempt to bring online drama and rhetoric into a formal legal setting where it just doesn't fit, and where it looks amateurish and counterproductive from a legal perspective.
And it wasn't just critics feeling this way. Even Baldoni supporters were worried.
Apparently so. The sources mention that even some people seen as supporting Baldoni were reportedly nervous about this brief and had actually urged the filer not to submit it. Seems they saw the potential for it to backfire.
The sources also delved into the filer's potential motivations, using some very strong language.
Yes, and again, it's crucial to stress these are characterizations from the source material. They describe the filer using terms like abuser supporter, agent of the patriarchy, even fan of rapist men. These are intense labels reflecting the commentary within the sources about the filer's perceived stance.
But the sources also included a detail that complicates the idea of the filer being some kind of plant.
Right. There's a mention that the same individual apparently protested at a film premiere for Baldoni previously, which, as the sources note, makes it seem less likely they were secretly working for Lively's side to make Baldoni look bad. It suggests perhaps they genuinely hold these views and chose this unusual way to express them.
It sounds like, based on the source descriptions, this brief tried to change the whole conversation.
That's a really key observation from the sources, yeah. Instead of talking about defamation law or the specifics of the anti-SLAPP statute or the alleged facts of what happened on set, this brief apparently tried to reframe the entire case.
Reframe it as what?
As like a big battle between Me Too and anti-Me Too forces.
Right.
A culture war proxy fight, which shifts the focus completely away from the actual legal questions Judge Lehman has to decide based on the law and evidence presented in the case. And that kind of reframing usually isn't very effective in court.
Could this whole incident actually clarify things for people watching the case?
The sources suggest it might. For someone who's genuinely neutral, seeing the stark difference in the types of support showing up. On one side, you have established advocacy groups, lawyers filing formal briefs focused on the law. On the other, you have this filing described as opinion, rhetoric, maybe fake citations.
It highlights a difference in approach.
Exactly. It might make it clearer, the sources suggest, which side is attracting support based on legal principles and established procedures, and which side is attracting support, well, characterized by the sources as being driven more by online ideology and less by legal substance.
Okay, so that's the saga of the Amicus briefs. Really fascinating contrast. But the source material didn't just cover that. It gave some other context on the broader case, too.
Right. Several other details emerged from the sources that add more layers to the whole situation.
Like the atmosphere in the film set itself.
Yes, the sources mentioned an account from the intimacy coordinator on that production. They reportedly described it as a tense set and specifically noted Blake Lively seemed more closed off during that shoot compared to a previous project where working with her was apparently extremely easy.
So offering a little glimpse into the environment where the alleged events took place.
Exactly. Just another piece of context floating around as reported in the sources.
What about Lively's own legal claims? Is she backing down on anything?
The sources specifically clarified that, contrary to some earlier reports apparently, Blake Lively is not dropping her claims for emotional distress.
Okay, so she's still pursuing damages for the psychological impact she alleges.
That's what the sources indicate, yes. Those claims remain part of her side of the legal fight.
The sources also contain some pretty serious allegations directed at Baldoni's lawyer, Brian Friedman.
This was a significant point, yeah. The sources detail allegations from multiple people, at least 6, across different cases against Friedman.
Allegations about his tactics.
Yes. They claim, according to the sources, that he uses things like fake websites, burner accounts on social media, and threats to leak stories to the media to basically intimidate opponents and pressure them into settling.
And again, just to be crystal clear, these are allegations reported in the source material from people involved in other cases.
Absolutely critical distinction. These are claims being reported about him from other contexts. But as the sources present it, these allegations paint a picture of a certain aggressive legal style.
Which is interesting, in a case where his own client is suing over alleged smears and lies.
It definitely adds another complex layer as the sources frame it. You have allegations of smear tactics being made against the lawyer representing a client who claims he was smeared. It highlights how the conflict and the narratives around it extend even to the legal teams involved.
The sources also showed the wheels of justice are actually turning, right? Yep. Specific court actions.
Oh yeah, the formal process is definitely moving along, separate from all the public commentary. The sources mention specific rulings by Judge Lineman from March 6, 2025.
What did he rule on?
He denied a motion to compel filed by Wayfarer, that's Baldoni's company. He also denied a request from Lively to dismiss 2 of her own claims under a rule about amending filings. So he's actively managing the case, making procedural decisions.
Any other case updates mentioned?
Yeah, the sources noted that Jed Wallace dropped a related claim against Lively, and that another individual, Sarah Nathan, formally appeared in the case with her own lawyer. These are just concrete examples of the litigation progressing through the formal court system.
What about that petition for Baldoni that was mentioned?
Yes. The sources noted a petition was circulating publicly in his support, but the commentary there suggested it's likely totally irrelevant to Judge Lehman and the actual legal case.
Why irrelevant?
Because courts generally don't make decisions based on online petitions. They look at evidence, law, filings that follow the rules. The sources also contain speculation that the petition might be inflated by bots, again highlighting the gap between online activity and real-world legal impact.
And one last point from the sources, something about media influence.
Right, there was an observation about Penske Media's influence, suggesting that Friedman had allegedly leveraged it in the past, but that its power to shape the narrative around this particular case might be waning.
So a little peek into the media strategy side of things as well.
Yeah, just another angle mentioned in the sources, suggesting how media relationships can play into these high-profile legal fights.
Okay, wow. We have covered a lot of ground. We started with the idea of amicus briefs, these formal friend-of-the-court filings.
Right, designed for experts and organizations to provide real legal insight or context.
Then we saw how that played out, according to sources, in the Lively Baldoni case.
Yeah.
You had the conventional briefs filed by advocacy groups, by lawyers, following the rules, supporting Lively's motion based on the law.
And then the unconventional one, filed supposedly supporting Baldoni, but described in the sources as coming from a non-lawyer YouTuber, filled with opinions, social grievances, MRA garbage, victim blaming, maybe even made-up citations. A stark contrast.
We also folded in those other details, the atmosphere on set, the claims against the lawyer, the actual court rulings happening to get a fuller picture from the source material.
And it really paints a picture of these two worlds colliding, the structured, rule-bound legal system and the much messier, opinion-driven world of public discourse and online commentary trying to barge in.
And the attempt to use that unconventional, opinion-heavy brief. Based on the sources, it seems like the consensus was that it didn't just fail, it might have actively harmed the side it was trying to help.
It really underlines that the courtroom operates on a different currency. It values evidence, legal precedent, reasoned argument based on the specific facts and laws of the case. Passion, volume, online rhetoric. That just doesn't translate well in that formal setting.
So this whole deep dive gives us this incredible snapshot of that collision.
Well,
why should you, listening to this, care about all this?
Well, I think it matters because it's a microcosm of a bigger challenge we all face, right? We're drowning in information, claims, narratives, especially around big public conflicts. This case study really highlights the difference between just having an opinion or expressing support online versus actually engaging with a formal system like the courts.
Which requires a totally different approach.
Exactly. It demands substance, evidence, adherence to rules. It's a reminder, really, to be critical consumers of information, to understand the difference between passionate belief and credible, relevant input, especially when things move from the public sphere into formal arenas like the judiciary.
Okay, so let's chew on this then. We've seen this stark contrast, the legally grounded briefs versus the one described as trust me bro logic. We've heard how judges have the power to filter out noise. We've seen attempts to shift a specific legal fight into a broader culture war, and all the surrounding claims and counterclaims from the sources. Leaves you with a question, doesn't it?
What are you thinking?
In this age we live in, right, where online talk is incredibly loud, often totally lacking nuance, and seems geared towards going viral, how effectively can these old-school traditional systems, like the courts, really insulate themselves? How well can they maintain their focus purely on facts and law when all this external, often opinion-based noise is actively trying to push its way in? What is this specific story, this contrast between the briefs? Tell us about the real value, or maybe the futility, even the potential damage of trying to influence a legal outcome from the outside using arguments that aren't grounded in law or evidence.
That's a heavy question. It really gets to the heart of how different systems value and process information. And it's a tension we're likely going to see play out again and again. Definitely something to think about.